put it after the Boksburg court, but allegedly Sergeant Mokhanu, who was the driver of a vehicle identified and put to him by Mr. Mngomezulu as white in color, with a hard body, and this, which Mr. Sergeant Mokhanu concedes, accused number 4, the vehicle, the SUV, is not linked to the evidence of the auto by Sergeant Mokhanu. And during the stops at these various locations, it is also put to the sergeant that, etc., that when you AVL system, it is part of the vehicle. The other, and having been taken under cross-examination by Mr. Mngomezulu in the same court. This is not a case where you find a witness testifies and is cross-examined, and allegedly the cross-examination and the re-examination is finalized, and the witness moves out of court, goes to the Kruger National Park for a holiday or to be employed there. And after 3 months, 6 months, the state gets a brainwave to recall that witness. No, this witness is contemporaneously and instantaneously testifying in this court. When Mr. Baloyi launches an application to re-examine this witness on the system, which allegedly tracks, he says it's an eye in the sky, it tracks the movement of the vehicle. Maybe with the fact that decided after the time court, and also section 35(5) of the Constitution kicks in, because after the accused has been charged, and don't get me wrong, there is no, so the duty of a prosecutor is to place by the state. But after having listened of a state case, and in this case, in some instances, can be closed or further adduce evidence of a witness who never even testified in that case. If it is in the, like I say here, we are not even dealing with that exigency. 074/2014. And the only debate the court had in this regard was whether the further evidence should be adduced in terms of affidavit, or the court must be remitted back to the High Court for that evidence to be heard. But the principle is that with herpes, but the attorney who was defending the gentleman who allegedly raped her and infected her with herpes, no medical examination was conducted because of that exigency. And this case was handled by my brother Mushidi. The SCA said that exigency is so important because it's determinative of whether that person will be acquitted or not. It was found that he does not have herpes, so he couldn't have had intercourse with this lady. But I'm just trying to demonstrate. So the paramount, the state must conduct such prosecution without fear, favor. What is the duty which is imposed on Mr. Baloyi? And that be made available. Proper real evidence should also be produced. Obligation to ensure that an accused's right to a fair trial is protected. And this is so because of our consequent with. He says this evidence to Sergeant Mokhano, namely that he was taken to various avenues and locations and assaulted, meaning that this Peugeot, this Fortuna SUV, traversed various locations, and consequently the state apparently is in a position to countervene. All the police, they actually told him, is he still alive? That's how murderous they had assaulted him, this police. And you know, this case has got to do with reputational damage. Two senior police officers, Bodlo, who allegedly took one of the confessions, and Rapadu, who allegedly took the other confessions, they are alleged by accused number 2 to have been instrumental in orchestrating what Mr. Ngumezulu calls a severe assault and a severe torture of accused number 4 in order to extract a confession from him. These are senior police officers. That exigency to the relevant authorities. Consequently, that is why this court must have access to all the evidence in order to traverse all the evidence objectively. I've got a case here which was conducted by Ronald Sutherland. Where he states that if it comes to the notice of an investigating officer during his or her investigations relating to forensic, the prosecutor about that exigency. And he says this is so because the investigating officer is in a special representative position vis-a-vis the prosecution because he assists as an investigating officer the prosecutor to prepare the case and to prepare the evidence. And in this case, for instance, the learned judge says because of that, and if the state wishes to pursue that aspect of evidence, because the state requires amplification or clarity or clarification or qualification testimony in question, and it because of the ought to blow is being argued. If there is a necessity to investigate a certain exigency which may have a bearing on the outcome of the appeal court says, in the interest of justice, that case must be remitted back. That additional evidence must be traversed. So in this case, it is unfair. Actually, the law doesn't even, and not having, as Mr. Ngumezulu states, made it a point that he investigates before charging the accused. No. As late as when Mokhano was being exposed to those assertions that comes across evidence, and I'm not arguing the state's case, which may throw evidence, which evidence may throw light as to whether that exigency exists or not. the court is bound and obligated and enjoined to hear that evidence. But here I hear Mr. Mgomezulu say, no, don't investigate. Don't listen to that evidence. I'm listening to the same case. He says, no, you mustn't listen to that evidence. Really? Is that evidence pertinent? Is that evidence going to enable the court to reach to the truth of what happened in the exigency which is denied by this witness, Mr. Sergeant Mokhano, and which is insisted upon by accused number 4? Accusatorial nature of criminal trials in South Africa demand that parties should, as far as possible, be given equal opportunities in the presentation of their cases. As I said, the state must be accorded all the opportunity to call and adduce relevant material to prove the owners reposing on it beyond reasonable doubt, and the accused should also be accorded a full opportunity to present evidence in rebuttal of the case against him and to challenge any evidence which is so presented. See in this regard the case of S versus Mpeta, 1983, 1 SA 492C at 494A to C. And see also the case of Director of Public Prosecutions, North Gauteng, Pretoria versus Makubelo, case number A91/2014, decided on the 6th of August 2014. And this is so because prosecutors are not practitioners who represent clients, but prosecutors are public officers who should assist the court in ascertaining the truth. And to enable the court to see that justice is done, the prosecutor is expected at all times to act in a manner which is responsible and fair to the accused and to be open and candid for this court, as Mr. Baloyi is attempting to do. He says there's evidence which, according to him, if this court not sees the court in ascertaining the truth. See in this 549 182C. But critically, this is what the TOIT says. And I'm adding cross-examination and re-examination. But this is what court's discretion to admit evidence for the state after the close of the defense case should be limited. Discretion to admit evidence for the state after the state has closed, after the close of the defense case should be limited to a situation where new matter is introduced which the state could not foresee. An inflexible rule, it's an injunction. Each case depends on the facts and the guidelines mentioned in the judicial case, and the new evidence may be allowed without injustice to the accused. Even here, where's the injustice? But the state submits that if need be, the manufacturers of that system will be called to come and give evidence in explaining the mechanism. That witness who's going to testify on the efficacy and the utilization of that AVLW machine. So there's no prejudice in hearing that evidence. I take note of what Mr. Mgomezulu says about the evidence of an expert. I'm aware of the cases. And also, I take judicial notice of what the former president of the SCA, Mpati, said about expert knowledge. He says it is not only acquired from going to university and environment of working in a particular workplace for some time. One acquires expert evidence sometimes. You can quote the case of Dr. Barnett, a black gentleman, I just forget the name of the gentleman, who actually taught him how to operate. Never went to school, that Xhosa gentleman. And you're Mr. Ngomezulu?
No, I'm not aware, man.
You're not? No. Were you born then? 1960 necessarily to acquire expert knowledge. You can acquire same by being in the environment. 91 SACR 481 SCA. It is also quoted by my learned colleague here, Ngumalo. Conditions mentioned by court's guidelines include the following: the reasons why the evidence was not put to Sergeant Mokhano. Officers, colonels abusing their position too by assaulting him. Visual evidence. Scientific evidence of a machine, not a human being. And I'm sure a machine is not biased. I've heard it relevant. And the reason is that it was, accused number 2 is available to rebut that evidence. SA 614. Which is relevant if you want the citation so that you can check it out. It's Hadla versus President Insurance Company Limited, 1965. 1 All South Africa, Report 603A. It was hit on the 24th of November, 1964, with Holmes and Williamson. It also dealt with the exigency when can one reopen a case and what are the consequences if you do so. Sorry, let's check. Yes, consequently, my judicial discretion, as enunciated in section 197, and the notes under